Encounters. My name is Valerie Mirko. I am a partner at Armstrong Teasdale and the leader of the firm's Securities, Regulation, and Litigation practice. I'm super excited to be here for the second episode of the second season of the Securities, Regulation, and Enforcement series within Brief Encounters. And with me is my co-host, William Nelson. William, can you go ahead and introduce yourself?
Yeah, thanks, Valerie. And also very excited, moving on to the second season. William Nelson, Public Policy Director and Associate General Counsel for the Investment Advisor Association. And I'll also go ahead and introduce our wonderful guest today. It's Dan Sommers. He's a partner at Cohen Milstein. He's a highly regarded and deeply experienced securities litigator, and also a thought leader in the areas of securities and class action litigation and investor rights. And Dan, we are so excited to have you today to talk about this topic. And if you want anything else, feel free.
No, terrific. Great to be here. And nice to be working with you, Valerie and William.
Yes, we're delighted that you're here, Dan. And I wanted to give our listeners a little bit of background as to how this episode came about. For those of us who've been listening since season one, we've really focused on regulatory topics. We've had guests, for example, from the SEC. And then we've also looked at the issues through a more general point of view, including sort of the defense bar side. But it occurred to us, particularly with discussions with some of our other community subcommittee chairs, that we really needed to have the plaintiff side represented as well on the podcast. And since this is the 30th anniversary year of the PSLRA, we thought a great way to introduce the topic was to discuss the statute and how it has evolved over the last 30 years. So, Dan, to kick us off, could you tell us a little bit more about the circumstances under which the PSLRA was enacted?
Certainly. The drafting of the PSLRA had its genesis in the mid-1990s, prompted by both legislative, institutional, and academic concerns about the utility of securities class action cases, as well as concerns about perceived abuses by some of the lawyers who were bringing these cases. Specifically, the concerns included the perception that securities class actions were generated by and for the benefit of plaintiffs' lawyers, that cases were not being controlled or supervised by the plaintiff, that many plaintiffs had small economic interests in the outcome of cases and therefore really had little incentive to supervise their counsel, and that some of these investors were in fact repeat or so-called professional plaintiffs, and that many cases were simply filed too quickly and were poorly investigated and lacked merit. Prior to the PSLRA, there was virtually no involvement by sophisticated institutional investors in securities class action litigation. There was also the perception that these cases imposed undue costs on issuers, especially relating to the cost of discovery, which can be very expensive and very expansive in scope and time-consuming. In particular, discovery in securities class actions can involve the production and review of hundreds of thousands or sometimes millions of pages of documents, as well as dozens of depositions, and often very extensive and expensive discovery. So there was, at that time, a view by some that the costs of these cases outweighed their utility, including the benefits they conferred on investors. And the debate lined up as a fight between, on the one hand, business-focused groups such as the Chamber of Commerce and Business Roundtable, as well as public companies, including especially high-tech organizations which saw themselves as frequent targets of these cases, and on the other hand, plaintiffs' lawyers and pro-investor right groups who advocated for the importance of these cases. And both sides certainly lined up academic input to support their views. In general, the intent of the proponents of the PSLRA was to pass legislation that would, among a variety of other things, eliminate or at least substantially reduce what they perceived to be meritless cases, also to establish procedures to slow the speed with which cases were filed by eliminating what was described as a race to the courthouse. That is, before the PSLRA, plaintiffs' lawyers were believed to be incentivized to quickly file cases on behalf of retail investors with very small investments after disclosure by an issuer of some adverse information, which would be followed by a drop in the stock price. Because the first plaintiff and their counsel to file the case would often be awarded control of the case. Proponents of the legislation also sought to replace so-called lawyer-driven litigation that was led by by investors with substantial financial interest in the case, presumably sophisticated institutions that have better capability and the economic incentive to supervise the case and their counsel then do smaller retail investments with minimal investments at stake. Finally, the sponsors of the PSLRA also sought to enact a statutory scheme that would reduce the agency costs of securities class action cases. Again, especially those presented in the extensive fact and expert discovery phases of securities class actions. So in late 1995, a conservative Republican Congress passed the PSLRA. As I indicated, the statute was highly controversial as its critics, including plaintiffs' lawyers, argued that it would impose such significant burdens that it would be harmful to the rights of investors and would preclude even meritorious cases from proceeding, and that courts already had ample tools to address any of the concerns stated by the bill's proponents. Notably, this view was shared by then President Clinton, who expressed his concerns about the proposed legislation and actually issued a veto of the PSLRA, but that veto was overridden by Congress. As a result, by the end of 1995, all of the participants in securities class actions, plaintiffs and defense lawyers, investors, public companies, and the federal judiciary were faced with a dramatically different landscape.
Thanks, Dan. And I think that's really interesting, kind of the genesis of the PSLRA and how it came about. But again, I'm a policy and regulatory attorney, and you're definitely the expert on these issues. So I was hoping maybe you could walk through, for us and our audience, some of the more significant provisions of the PSLRA.
Certainly. So let's start with the provisions impacting how cases are organized at the outset, which are commonly known as the lead plaintiff provisions. The PSLRA changed the process by which both the lead plaintiff and their counsel are appointed by the court. Before the PSLRA, courts typically gave control of cases to the investor that filed the initial case, regardless of the size of the investment or the loss sustained by that investor, and regardless of the quality of the complaint they filed or the quality or capabilities of their counsel. In response to this, the PSLRA created a very specific structure and methodology that district courts must follow when appointing the lead plaintiff. This process remains unique to securities class action litigation. The statute provides that the investor filing the initial case must issue a public notice of the filing of the case to advise all investors that they have 60 days within which to file a motion to be appointed as the lead plaintiff. Each such application for appointment must be accompanied by a certification signed by the proposed lead plaintiff certifying that they authorize the filing, that they are willing to serve as a representative party, that they were not induced to do so by counsel or by any expectation of any payment other than their proportionate share of any recovery. They needed to state whether they had served as a lead plaintiff in more than 5 cases in the preceding 3 years, as well as attesting to all of their relevant transactions in the securities at issue in the case. The PSLRA also directed district courts to evaluate within a 90-day time period all applications of investors to be the lead plaintiff and select as the lead plaintiff the investor or the group of investors with the greatest financial interest in the case, provided they also satisfy the class action requirements of Rule 23. So the statute largely divested courts of sort of the broad freewheeling discretion to appoint lead plaintiffs that they previously had, and eliminated the ability of courts to simply appoint the investor that files the first case or on some other basis. And by establishing the 60-day window within which to file lead plaintiff motions, it sought to eliminate the race to the courthouse and to encourage a more capable type of plaintiff to control these cases. In addition, the PSLRA also imposed a mandatory stay of all formal discovery pending resolution of defendant's motion to dismiss the complaint. While there are exceptions to the stay, they are very limited, and there is a heavy burden on plaintiffs to make a showing that they are entitled to any discovery until the complaint survives a Rule 12 motion to dismiss. Previously, district court judges had discretion to permit discovery to proceed while a motion to dismiss was pending. Based on my experience before the PSLRA, it was not uncommon for plaintiffs to be able to obtain at least some discovery from parties and non-parties prior to the resolution of a motion to dismiss. The information obtained in these circumstances was sometimes very helpful in permitting investors to bolster their existing complaint and to file a more fulsome amended complaint. This provision of the PSLRA almost entirely eliminated this option from the arsenal of investors. Another critically important change that the PSLRA enacted was the heightened pleading standard that requires plaintiffs to plead their complaint with particularity and plead facts that give rise to a, quote, strong inference, in the word of the statute, that each defendant acted with scienter. The statute did not define what it meant by strong inference. Not surprisingly, district courts and appellate courts, including in at least one instance the Supreme Court, issued hundreds of opinions interpreting that phrase and applying it to the unique facts of each case. While most securities cases were already subject to the pleading requirements of Federal Rule of Civil Procedure 9b, the PSLRA attempted to go beyond that and to impose even more requirements for specificity in the complaint. The intent was to permit only cases with a strong factual basis to support allegations that public companies and their officers and directors made statements that were false and misleading, and that they acted intentionally or recklessly to mislead investors. This standard is, to my knowledge, higher than the standard in any other form of federal civil litigation. The PSLRA also enacted a safe harbor for forward-looking statements made by public companies. While this concept was previously embodied in various forms in case law, the PSLRA made it an express statutory defense. This was an attempt to codify and clarify protections for issuers and to encourage them to communicate with investors about matters other than those of historic or current fact, such as projections and forecasts and statements about future business plans or future economic performance. In general, the PSLRA immunizes issuers from liability for these types of statements if they were accompanied by meaningful cautionary language, or if the information was immaterial to investors, or the plaintiff fails to prove that the speaker made the statement with actual knowledge of its falsity. In addition, the PSLRA also addresses loss causation, which is an element of a securities fraud claim, and imposed on the plaintiff the burden of proof of proving that the alleged false or misleading statements caused the loss for which plaintiffs seek damages. And as to damages, the statute created a cap on recoverable damages. It limited damages to the difference between the purchase price and the mean trading price of the security during the 90-day period beginning on the date on which the information correcting the misstatement or omission that is the basis for the action was issued. The intent of this provision was to limit damages by preventing a perceived windfall to investors in situations where a corrective disclosure causes a drop in the stock price, but the stock price subsequently rebounds in the following 90 days. The Reform Act also changed prior practice by limiting the instances when joint and several liability will be available to plaintiffs to only cases where there is a finding that the defendant knowingly violated the federal securities laws. Otherwise, liability for any judgment will only be allocated on a proportionate basis. The PSLRA further required that district courts make findings at the conclusion of each case as to whether any party or their counsel violated Rule 11 and whether sanctions are appropriate. Again, this is another attempt to deter what were perceived as meritless court filings. And finally, the statute sets out specific requirements for the contents of any notice of a proposed settlement, including information describing the range of potential recoveries, had the case gone to trial, details about the fees and expenses sought by plaintiff's counsel, and the reasons for the proposed settlement. So those were the provisions I wanted to highlight.
Dan, that is a super helpful background, especially for those of us like William and me who do not practice in this area. One of the things we talk about a lot on this podcast series is the impact, whether it's of a regulation, a statute, an industry development. So following that format, now that we've walked through the most significant provisions of the PSLRA, how would you characterize the overall impact?
Well, Valerie, in general, the PSLRA has indeed unquestionably changed how securities class actions work, especially from the plaintiff's perspective. As to the success or failure of the statute when measured against the goals of its proponents and the legislative intent, the results really have been mixed, with both sides happy about the impact of some provisions and unhappy about others. As to specific impacts, let's start with the objective of increasing the participation of sophisticated institutional investors. 30 years of data now shows that the new lead plaintiff provisions certainly achieve that objective and has substantially increased the participation rate of institutional investors, mostly domestic public pension funds, municipal and public safety funds, Taft-Hartley funds, and some large non-US based funds. That objective has not been met across the board, however, as notably absent from the landscape is participation from mutual funds, university endowment funds, and hedge funds, which generally seem to be litigation averse. And institutional investors have not taken over the entire field. In fact, the overwhelming majority of initial cases are still filed by retail investors, and the data indicates that a substantial percentage of lead plaintiffs appointed are retail, not institutional investors. One study indicates that between 1995 and 2002, institutional leadership in these cases increased from virtually zero to about 27% of all cases, and that between 2010 and 2012, that rate increased to about 40%. And my firm's own internal analysis of 2024 filings is generally consistent with this data. So the goal of increased institutional investor participation has been met to a meaningful degree, but it has not come close to eliminating the role of smaller retail investors. The data also shows that the increased participation of institutional investors is associated with lower dismissal rates and larger recoveries for investors. Indeed, all of the historically largest investor recoveries from securities class actions after the PSLRA have been associated with institutional investors serving as lead plaintiffs. By this measurement, the PSLRA did achieve one of its most important stated objectives of encouraging large meritorious cases to proceed. In addition, there is also evidence that the participation of institutional investors who are sophisticated and more able to negotiate fee caps with their counsel has resulted in lower fees on a percentage of the recovery basis. This results in greater per share recoveries for investors. So again, by this metric, the PSLRA has achieved at least to some significant degree its objective of controlling costs and fees and increasing net investor recoveries in meritorious cases. The objective of eliminating the so-called race to the courthouse, however, plainly has not been achieved, largely, in my view, because the drafters of the PSLRA did not fully understand the dynamics of how securities class action cases work. So we still have a system where initial cases are filed shortly after the disclosure of an adverse event, typically with a small retail investor as the plaintiff, which triggers the 60-day period for other investors, including institutional investors, to step forward. Indeed, only very rarely does the first to file plaintiff get appointed as the lead plaintiff. In addition, and this is on an anecdotal basis, I've observed over the last 30 plus years that the quality of work from the plaintiff side generally has improved, including the factual specificity in the operative complaints that are filed. And this is especially true in cases with institutional investor participation. Nevertheless, in general, the dismissal rate on securities class action cases is still well above 50%, and defendants unsurprisingly move to dismiss virtually 100% of the cases that have been filed. So one could look at these facts in different ways, including that there are still too many weak cases being filed, or that the PSLRA has worked to weed out weak cases at early stages, or that the hurdles imposed by the PSLRA are simply too high and that potentially meritorious cases are now being extinguished prematurely. There is, however, no doubt that the automatic discovery stay provision has met its stated objective, even though it remains perceived by the plaintiff side as too inflexible and unfairly tipping the scales in favor of the defense side. This provision has almost entirely thwarted plaintiffs' ability to obtain any formal discovery until the resolution of the motion to dismiss. And interestingly, it has had the collateral impact of encouraging plaintiffs' counsel to improve their pre-filing investigation skills. And now they are able to conduct very robust investigations, including the identification of witnesses, including former employees of the issuer, and to obtain important information that is used to bolster the allegations in the complaint. The automatic discovery stay, however, along with the statutory lead plaintiff process, has also contributed to increasing the duration of these cases, as the lead plaintiff process, then followed by the filing and litigation over the amended complaint, can often take 6 months to 1 year before any formal discovery can ever proceed, which is, of course, very bad from the plaintiff's perspective. As to the heightened pleading standard, there is probably no one who's fully happy. It has required the application of judgment and interpretation by courts, which has resulted in both sides being less than satisfied with certain outcomes, with plaintiffs believing that too many cases are being dismissed and defendants believing that the dismissal rate is still too low. Finally, it does not appear that the number of cases filed has been impacted by the PSLRA. There really is no evidence that generally there are fewer cases filed post-PSLRA than pre-PSLRA, and there is no clear evidence that the total number of cases per year has materially risen or declined over time. There is certainly no evidence that I've seen of any causal relationship between any of the PSLRA's provisions and a change in the number of cases filed. While there are ebbs and flows in the number of cases filed per year, they generally range from the mid-100s to the mid-200s, and it is really more likely that factors such as company-specific disclosures, general market trends, more directly impact the number of cases filed in any given year, rather than anything caused by the Reform Act. So to the extent that an objective of the PSLRA was to reduce the total number of cases, a goal with which I did not share, that goal has not been achieved.
So, Dan, I really appreciated your descriptions of the impact of the PSLRA. Looking at it as a defense side lawyer, It would seem to me like the impact is a little bit of a mixed bag. I could, for example, see that the PSLRA is a step in the right direction from the defense side, but I suspect defense lawyers would say there's a lot more that could be reformed. And it also sounds like there were some unintended consequences that were beneficial to the plaintiff side. Did I hear you correctly?
I think that's absolutely correct. I think there are aspects of the Reform Act that the defense side certainly is pleased with, and one of those is the automatic discovery stay. I think in general, the heightened pleading standard is something that the defense side is pleased with. Although, on the other hand, I think that they, from time to time, are unhappy with the way judges interpret that provision of the PSLRA and would be hopeful that more cases would be dismissed. Similarly, the change in the lead plaintiff process has had some benefits for the at least certain aspects of the plaintiff side. And I think everyone agrees on the plaintiff side that the increased participation of institutional investors in these cases is a good thing and has resulted in better outcomes for investors. So I think both sides look at the statute that some of it has been beneficial, some of it hasn't worked out as they wished.
Thanks, Dan. I think that's really helpful, for our listeners, just the impact. We've talked about the genesis. We've also talked about some of the significant provisions, but now I'd like to switch gears just a little bit and kind of, ask you to discuss, maybe some recent developments or trends that you're seeing in this area. But also, we have a brand new administration, brand new Congress. Do you anticipate any changes to the PSLRA in the near future?
The short answer, William, is that I don't, with a significant caveat that I'll repeat, which is that in the current environment, it's hard to predict what is going to come down the road. The reason I say that is the PSLRA's procedures and rules are now very well established and are familiar to counsel and investors and courts, especially in districts where there's substantial amounts of securities class action filings. And all of this is deeply ingrained in the securities law jurisprudence by now. So, in fact, at this point, most practicing lawyers and judges have never even experienced securities class action litigation without the PSLRA being in place. So again, it doesn't appear to be any public momentum for legislative change to the PSLRA. Again, on our current environment, it's hard to predict what issues may take hold in Congress or in some other regulatory setting. And as we discussed, clearly both sides would like certain provisions to be changed. As we've mentioned, the defense side would like other mechanisms, perhaps to reduce the number of new cases or to force courts to adopt a more restrictive view of what is needed to satisfy the heightened pleading requirement and to make pleading and proof, for example, of loss causation even more difficult. On the other hand, as I mentioned, plaintiffs would like more flexibility to obtain at least some formal discovery at an early stage in the case. But again, there is no imminent reason to believe that there are will be any changes in terms of legislation, any change to the PSLRA or otherwise. So to me, it really appears that at this point, the PSLRA substantially in its current form is here to stay for the long haul. We should expect that a subset of institutional investors will continue to take their fiduciary duties seriously and will take leadership positions in a substantial number of cases, especially where there are serious allegations of misconduct and significant losses to investors, though there still will be an important role for retail investors. So again, sort of summarizing what we've talked about earlier, we should just expect that both sides will continue to have to work with less than what they perceive to be a full loaf of their PSLRA wish lists, and they'll be satisfied with some of its provisions and dissatisfied with others.
So, Dan, I think this is a really great note to end on. Thank you so much for joining us. on our February episode of the Securities Regulation and Enforcement series of DC Bar's Brief Encounters podcast. I did want to mention for our listeners, we are recording this episode on February 11th, so it'll be out in a few days this month. But of course, there's been a lot going on, both in terms of DC, the federal government, and the SEC specifically. So we will be picking those developments back up in our March and April episodes. Dan, thanks again so much for joining us. And William, we'll talk again next month.
Thanks so much.
Thanks, Valerie.